So thank you very much, everyone, and welcome to the African Summit of the Global Perspective Corporate Governance Legal Tactics Project. This morning, we had a very interesting discussion with the keynote from Justice Preston on justiciability in climate litigation, and then to high-level panel on causes of action, and then on procedure and evidence in corporate governance litigation. This afternoon, we start with the high-level panel 3, that is on remedies in corporate climate litigation. So just let me give a few thoughts about this coming from our work with the Global Toolbox on corporate climate litigation. As you know, we have two kinds of main categories of remedies. We have the pecuniary remedies and the non-pecuniary remedies. The pecuniary remedies are awarded so far and involved both compensatory damages and punitive measures through fines. This is something that we saw in very different legal systems. As already said during this morning, our project worked on 17 countries, so we saw compensatory damage in Canada, China, Australia, and these kind of punitive measures through fines, something that is more likely to happen in the US and India. And emerging cases reflect a growing trend towards seeking diverse forms of compensation and accountability for climate-related damages. And these efforts include claiming climate damages for deforestation as an independent category of damages. This was the case, for example, in Brazil, demanding funding for climate change adaptation, and expanding the scope of climate-related damage to cover moral harm. This is something that we saw, especially in France. So, legal developments that we've seen during our comparative law project in the US, in Australia, too, have shown initiatives to levy financial penalties on directors and officers for failing to fulfill the climate-related fiduciary responsibilities. And there is an absence of reported cases or success in claiming this kind of category, the pecuniary remedies, in several jurisdictions. And this generally is attributed to case dismissal due to lack of merit or procedural issues. This latter might indicate a possible shortfall in the legal framework, especially in providing financial remedies for climate-related damages and also accurately calculating them. So the inadequacy of monetary remedies to comprehensively address climate change extensive consequences underscores in a way something that we saw in our project, that is corporate climate litigation inherent limitations. And that's why we have also studied in much depth the non-pecuniary remedies, which, as you probably know, its key include injunctions. This is something that is common in Canada, Brazil, Germany, Poland. We find in very different countries, of course, in the US. And of course, the declaratory relief, which have been used in Canada and India, but also preventive measures like in France and in the Netherlands, as you probably all know, and restorative measures, notably in Germany. Other approaches that we had the chance of reviewing and studying with our rapporteurs include also public civil action in Brazil. There is the famous, I would say, writ of Caricatan and continuing mandamus in the Philippines, and specific performance orders in the UK. This is something that poses incredible challenges and hurdles. The challenges faced in implementing non-pecuniary remedies are seen particularly in countries like Nigeria and China, as we are going to see, as we saw already a little bit in the discussion. There was some mention to this, where economic consideration play a significant role. For example, the Nigerian courts, as was highlighted by Dr. Usuazo, show hesitation in issuing injunction against oil and gas company to avoid economic disruptions. And there is also a high threshold for proving concrete danger and causation in Japan, reflecting this judicial cautiousness. And the balance between domestic public benefits and environmental harms is also something that was, in a way, mentioned by Justice Preston this morning. So we have a very interesting panel today, and we have been joined by 4 great speakers. So here with me on the panel in person there is John Mariri. John is a holder of Bachelor of Law degrees from Moi University. He's an advocate of the High Court of Kenya, certified public accountant and certified public secretary. He's also previously worked at the firm of Ogiek and Ivano. Advocates his career in the human rights field started the Kenya Human Rights Commission before joining the Law Society of Kenya. And now he's currently practicing law at Kiko Kasheria, I hope that I pronounced correctly, where he specializes in civil litigation, succession, labor, and human rights litigation. This is really something that is relevant also for this panel. So I will start maybe with John before introducing the other panelists. John, we are talking about these remedies. In your experience, what you, in the case that you had the opportunity to litigate, to defend, what is the most interesting remedy that you saw in this context of climate litigation involving business?
Thank you very much. I'm indeed very happy to be joined with you in this meeting. I'll talk briefly about the remedies that are provided in the Kenyan jurisdiction, and I'll also talk a bit on the case that we have filed. We have filed a number of cases touching on environmental law, but I'll talk about also the most interesting prayers that we have sought before the Kenyan courts. So the Kenyan jurisdiction also provides for pecuniary and non-pecuniary remedies. And for pecuniary remedies, we have general damages that can be sought from the court. And then we also have special damages and punitive damages that can be sought. These are pecuniary. And for general damages, mostly it's left at the discretion of the court. It's for the court to decide on how much any litigant that approaches the court on the amount that they can be awarded. And in most instances, we have seen that parties, and especially the state, has always appealed against awards that have been awarded by courts in Kenya. So basically, the value that is given by the court is left at the discretion when it comes to general damages. For special damages, that is left now to the litigant to provide evidence that this is the harm that they incurred as a result of a harm that was occasioned on them. And mostly you find that they have to prove this through receipts. Probably they have to bring a valuation report. This is always a big challenge because when you look at climate change, for example, and litigation around environment, it's very difficult, especially for indigent clients, to provide proof that this is the harm that they incurred. So for non-pecuniary remedies, in Kenya, we have a declaration of rights. I think this is the most interesting right that I live when I litigate around issues of climate change, because this is basically, you just need to prove to the court that this is the right, and you are just seeking the court to declare that this right, for example, has been violated. Then you can seek an injunction. You can also seek conservatory orders. You can seek a declaration of invalidity of law. In Kenya, for example, legislation, the Constitution of Kenya is above legislation. So you can seek a particular legislation to be declared as invalid. Then there is also the judicial review proceedings that you can file before the Kenyan courts. Then the Supreme Court of Kenya has said that this list or these remedies are not exhaustive. So it means that any party or the courts are free to quote any other remedy to ensure that right is protected. Thank you.
Thank you very much, John. It's great as an introduction. I will pass now the word to one of our panel speakers online, Clarice Wambua. Nice to see you, Clarice. So Clarice Wambua is a consultant at Pan-African law firm Cliffe, Dekker, Hofmeyer, where she leads the environmental law and pro bono human rights practice areas in the firm's Nairobi office. So Clarice frequently advises on legal issues related to climate change, clean tech, and carbon markets, and she works with a variety of entities, including community-based organizations, corporates, government institutions, and international development agencies. She also teaches at the University of Nairobi, with a particular focus on the graduate course on climate law and land use law. And Clarice is a member of the Law Society of Kenya and the expert advisory group of the Voluntary Carbon Markets Integrity Initiative, and the Legal 500 Green Guide, EMEA 2020-2025, recognized Clarice for her climate change and sustainability law work in Kenya. And in 2019, she was a recipient of the top 30 under 40 women in Kenya award from the Business Daily. So, Clarice, it's a great pleasure to have you with us. Thank you very much for joining us. And as was mentioned in the first panel, Kenya recently enacted carbon market regulations. So I would like to know from you what remedies exist for litigants seeking redress for corporate violation related to carbon project and engagement in the global carbon markets. Clarice, the floor is yours. Yeah. Can you please? Maybe it's okay. Yeah.
Thank you. I'm able to speak now. Thank you, Ivano. I wish I was there in person, but we thank God for technology. So with regards to your question, yes, Kenya recently enacted carbon market regulations. So previously in Kenya, before 2023, we had a Climate Change Act that came into force in 2016. However, it did not have provisions on carbon markets, or at least explicit provisions on carbon markets. So what happened in 2023, the act was amended, and then about 2 weeks ago, regulations to operationalize the act were gazetted. So this brings a very interesting dynamic, because previously it was difficult to really seek remedies on carbon projects. They've been ongoing in Kenya since 2005 when we had our first project. But we had even cases of communities having issues with projects. In most cases, those cases were resolved by the standard bodies, where you'd have complaints made at that level, and a project is suspended, a review is done. We'd also had instances where the county government would intervene, for example, to sort of try and resolve a dispute or a question arising on carbon markets. But we have had no cases in the courts on carbon market or carbon projects specifically. So the new legal and regulatory regime, with its mandatory provisions, has very critical remedies that it then provides that litigants can rely on. One, there would be remedies under contract law. The carbon markets regulations require communities to enter into what are called community development agreements between them and their investor or the project proponent. So definitely, it being a contract, then it has contractual obligations that arise. And therefore, if there was breach of this community development agreement, remedies could be sought under contract. And this could be utilized or sought through the court process. Only what one needs to note is that under the law, the first point of call is that the communities and the investor must try and resolve their disputes through alternative dispute resolution. And then if that fails within 30 days, then they have 30 days to then appeal to the National Environment Tribunal. And we know that appeals from the National Environment Tribunal then lie at the Environment Land Court. So it's just important to note that the remedies could be, you could be seeking damages for breach of contract, you could be seeking restitution, you could be seeking rescission, reformation, so there are many. Another important thing to note is that the new regime also introduces what I would say carbon trading crimes. So we did not have specific carbon crimes before, but now the Act of 2016 suddenly actually brings into place specific crimes, for example, trading, conducting unauthorized trade, selling to an unauthorized person, using the carbon markets for money laundering. And the interesting thing about this is that the penalty is quite high. It's 500 million Kenya shillings or 10 years imprisonment, or both. And so you could then seek a remedy through the criminal process as an aggrieved party, either through private prosecution or through the state prosecution. You could also seek remedies under civil law. And this, I think, has been mentioned by the speaker before about that we have different, you could get injunctions as non-pecuniary remedies, you could get pecuniary remedies as well. And you could also then use administrative law, and I think he mentioned that, as well as attempt to approach the courts by asserting the right to a clean and healthy environment has been infringed, and we know that a safe climate is one of the components of this right. So then you could also then seek diverse remedies on that basis. Yeah, in a nutshell, that's the position with the new regime.
Thank you very much, guys. It was really clear, and I think it's also great to start with that. I will now pass. I will now introduce you to Dr. Ekator, who is one of our Nigeria experts of the International Expert Group. So, Dr. Ekator is a senior lecturer in law at the University of Derby in the United Kingdom. His main research areas include international environmental law and natural resource governance. He's the chair of the Committee on the Teaching of International Law and the SDGs of the International Association, the Nigerian branch, and he's a senior fellow of environmental law and sustainable development at the Institute for Oil and Gas, Energy, Environment and Sustainable Development at the University of Nigeria. Dr. Ekator is the Deputy Editor-in-Chief of the Journal of Sustainable Development Law and Policy, and is also the co-lead of the International Environmental and Human Rights Law Research Cluster at the University of Derby Law School. So, dear Goza, thank you very much for joining us. I would like to start with a question about the barriers that are militating against effective remedies in climate litigation. What is your experience on that, also based on your studies in the African countries? Please, the floor is yours.
Thank you very much. Thank you for the opportunity to contribute to this wonderful workshop. I think for me personally, if you actually look at the Kenyan report on page 31, it says it's a trite law that where a cause of action has been established by a litigant, there must be a corresponding remedy. So in many African countries, in many developing countries, even looking at environmental justice as a starting point, there are loads of barriers that's already militating against having explicit climate litigation cases on the African continent. So I just list out a few of these barriers. So the first one for me that comes to mind is the lack of explicit climate change laws in many African countries. Even though you don't actually need the climate change law, the standard climate change law to ensure to lead to climate litigation. But in many African countries, there's no explicit or standalone climate change law. Also, access to justice issues in terms of what are the barriers. Do people have access to court? Can people actually go to court? And if people go to court, will they actually get justice? So another major issue that you might find in literature is about cost, in terms of cost. For example, local standard issues. Do people have standing? Do they have a legal standing to actually institute these cases? Then in terms of funding, can you actually fund it? Can litigants fund it? We talk about climate change affecting the most vulnerable in society, such as maybe women, indigenous communities, etc. Can they actually fund these climate litigation cases? And knowledge, do litigants who actually have the knowledge about these cases, and how can they leverage on scientific knowledge? And so I think, to me, those are some of the major issues. So when we talk about in terms of cost, what do you actually mean in terms of cost? For example, filing fees, for example, in many African countries, it's quite expensive to fight. The filing fees are very expensive. Then, if many of these courts, in terms of travel expenditure, travel costs as well, many of these courts are actually located in urban areas, and many of the victims of climate injustices live in poorer communities. To take the example of Niger Delta, for example, Nigeria. So the travel cost as well. Then you need to pay the lawyers. So it's not every lawyer that will do like a no fee case or do it pro bono. So you need to think about paying lawyers, and it's not actually cheap to get the best lawyers in this regard. Then what about the expert witness? Who's going to pay them? So these are some of the barriers in my mind that actually militate against climate mitigation cases. So if we talk about local standard, for example, in many African countries, especially in environmental cases, there has to be a direct connection between the litigant and the environmental damage, for example. So before they can actually sue, so this is a major obstacle in actualizing climate justice in many African countries. So I just give the example of Nigeria. Local standard, legal standard is a major issue in terms of environmental justice, environmental litigation, and even potential climate litigation. So even though the Nigerian government has enacted the Climate Change Act, and there's I know Dr. Zwazo mentioned the recent case in terms of the Center for Air Pollution case and NPC case, which says that in Nigeria, for example, environmental NGOs can actually institute cases on behalf of people that have suffered from environmental injustice. And even in my own papers, I've argued that that case, Center for Air Pollution case, can be reconceptualized as a climate justice case in the Nigerian context. However, local standard is still a major issue because, for example, that case was a decision by the Nigerian Supreme Court, and some scholars have said that until the finding or decision of that case is actually made into a law, another panel of the Supreme Court can actually reverse that case. And also, some scholars have actually said that the Nigerian Climate Change Act does not actually promote legal standing, so that it restricts legal standards. So in a way that even though there has been recent development in the Nigerian context, there are still issues around local standard. Then another issue is in terms of information. The knowledge of the population to be restricted if without access to relevant information. So access to information regarding climate change is very key to improve climate activism, to improve litigation. So another issue that comes to mind is that many of these new laws on climate change, for example, many of the environmental laws in many African countries do not explicitly promote environmental education, do not promote climate education. So to me, that are just some of the barriers that will militate against having effective remedies in the African continent. Thank you.
Thank you very much, Goza. That is really, really insightful. I would now introduce you, before starting with the second, I will introduce to Dr. Lydia Omuko Jung, our fourth and last speaker. Lydia Omuko Jung is an attorney specializing in climate change law, and she's also a senior legal consultant at Climate Focus, an international climate advisory firm based in Berlin. Lydia advises governments, private entities, and multilateral organizations on legal issues relevant to climate change projects and policies, including carbon transaction, climate regulatory issues, and also designing of mitigation policies. She has advised on and drafted carbon market regulation for several governments in Africa and South Asia, and she's also advised public and private entities on structuring carbon transactions, climate-related liabilities, and climate litigation. And Lydia finally previously worked in academia as a litigation counsel in Nairobi, and she's an author of publication on climate change litigation. And as you can imagine, she's also an advocate of the High Court of Kenya, and she holds a PhD in law and LLM climate change law and policy. Lydia, it's a pleasure to see you again. And reading the Kenya report, I saw that under the Section 23 of the Climate Change Act that was mentioned before by Clarice, a person does not need to demonstrate that they have incurred loss or injury to enforce climate-related risk. At the same time, the provision allows for the remedy of compensation. So my question is, in your opinion, what are the challenges of obtaining this remedy? And how do you see courts addressing this based on the history of environmental cases? So we continue with the hurdles and the challenges. Thank you, Lydia. The floor is yours.
Thank you, Ivano. I hope you can hear me clearly. Yeah, thank you for having me, and yeah, perfect. Thanks for having me, and yeah, congratulations to you and the BIICL team and Robert, as well as the ACON team, for organizing this summit. So just to touch on the issues that you raised and building up on what Clarice said, so we have Section 23 of the Climate Change Act, which allows entities or allows persons to enforce climate-related rights or to bring a case saying that someone has acted in a manner that has adversely affecting efforts towards mitigation and adaptation. And I have to say that this is quite a very good provision for those who've been in climate litigation for long, because we understand that one of the biggest issues or one of the biggest challenges is usually showing standing, causation, and this provision has actually liberalized these issues and allows anyone to go to court to enforce climate-related rights. And one of the most interesting things that it brings about is that the applicant does not have to demonstrate that any person has incurred loss or injury. So any person can come to court and file a case. But then, one of the remedies that it provides for is compensation, in addition to other remedies that are listed under Section 23. And I think for me the question is, the relief of compensation raises a number of questions, considering that one does not have to demonstrate loss or injury. For instance, the question would be, what would be the basis for compensation? How would the courts be able to assess compensation if you don't have to prove any injury? And I think the first speaker already highlighted that there could be general damages, which you don't need to prove, and the court can be given at the discretion of court. But then when you have issues like special damages, which you are required to prove, but then the provision says you do not have to prove any loss or injury, how would this be assessed? And if you look at environmental cases that seek to enforce environmental rights, which the Constitution has the same provision that allows anyone to approach court to enforce environmental rights, and a person does not need to demonstrate that they have been injured or anyone has been injured. And if you look at the history of courts in enforcing environmental rights, we see that there's the lack of rules or lack of guidelines on how compensation on environmental rights has actually resulted in conflicting jurisdictions on when and how much compensation is due. So we see a number of cases where courts have granted compensation simply in recognizing that a petitioner's right to clean and healthy environment has been infringed. So in some cases, they grant compensation. But then we also see that in other cases, the petitioners have actually been denied damages because they couldn't show any loss suffered due to the violation. So we see two conflicting approaches that courts are taking here. On one side, you are granted compensation just because your right to clean and healthy environment has been infringed. But then on the other side, you're told we cannot issue you damages because you haven't shown any loss suffered as a result of violation, even when the courts have found that rights have been violated. So this is one issue. And then the second issue we also see based on environmental rights cases and the issue of compensation is that where courts have issued compensation, where courts have granted compensation, it's usually unclear what the courts determine on the amount of compensation. So this, considering this lack of rules, lack of guidelines, and these conflicting decisions, we see that I think that a claimant in climate compensatory case is likely to be caught up in this ambiguity. And even though the provision is very good, although the Section 23 provides opportunities to bring cases and to get different remedies, I think the lack of clarity or the fact that courts have always given conflicting decisions on environmental rights then also brings climate cases in this ambiguity. And just to look at, for instance, examples of private cases, of some cases before, we see, for instance, there was a case, I think it was called the Ken Kasinga case, where courts have awarded 10,000 Kenya shillings. But then in some other cases, courts have given 30,000 Kenya shillings just in recognition that rights have been violated. So how courts have always calculated this is not usually clear. So I think this is an issue that climate cases are likely to be faced with. But just in conclusion, I think it's still a very strong provision compared to a lot of jurisdictions. It allows a lot of people, anyone, to approach court, which it has done away with the issue of local standard. It also liberalizes the issues to do with possession. So I think it's still a good provision. It still provides opportunities that legal provisions in other countries do not. But there needs to be some guidance or some clarity on issues to do with compensation.
Thank you very much, Lydia. Yeah, this is also quite comforting. I will get back to you also on that point because I'm really interested to see what this could be, what this could mean also for the other countries. We, as you know, we try to also to explore with the toolbox what are the possibilities that we can, in a way, circulate, disseminate from one country to another. So now let me go back to John. So John, also considering what we've been talking with Goza, with Lydia, what is your experience with these kind of challenges that they mentioned? What kind of challenges, hurdles you encountered as a practitioner in seeking remedies for climate change?
Okay, thank you so much, Ivano. I think the major challenge that I've experienced relates to the indigence of the clans we represent. Invariably, it seems that most of the persons affected by climate change, the poor and the marginalized. So whenever we represent them, we find that if an organization like ours, for example, Kituo cha Sheria, had not come in to assist them, most probably they will not be able to approach court. So I see a situation where most of the poor and marginalized clients are unable to access justice just because of lack of filing fees, for example, lack of fees to pay an advocate, for example, legal fees. So that is the major challenge. The other challenge, again, related to finance is also to do with getting an attribution expert. You find that just to attribute the phenomenon that is happening to climate change would require an expert. And this is quite expensive for most of the poor and marginalized clients. Minority groups, I believe they are unable to just get that attribution expert. And I also found out that the attribution expert that you get, for example, is from the state. And this also brings aspects of conflict of interest. Again, you have filed a case against the state or the government, and the only expert probably you are having is a government expert. So that is a major challenge that I have experienced. Another challenge is, again, proving damages. You find that probably you need an expert to come and prove that this is the specific damage that this community, these litigants have suffered. So you probably need a valuer to come and value. This is money, and most, like I've said, are poor and needy clients. The other challenge in accessing remedies is the politics that come in a case. You find that this is a vulnerable community against a corporate, for example, and you find a corporate bringing in politics in a case, in that you find that some of the litigants are actually compromised, they are given money and they start dropping out of a case. So at the end, you find yourself that you have this harm to the environment, for example, but you don't have the victims, you don't have a community behind you. But we have found ways of going around it and trying to see whether we can bring in, for example, organizations to be the first petitioners and the community, for example, coming in. But again, politics is an aspect that needs to be looked at because this may lead to inaccess to justice. Thank you.
Thank you very much, John. And I would like to ask you basically the same question also to Clarice. As we said, Kenya has what appears to be an enabling legal framework for those seeking redress for environmental harm. What are for you the likely challenges, if any, to be faced by a litigant seeking remedies for climate harm in Kenya? Clarice.
All right. Thanks for that. I think John has really covered most of the ones that I've also like experienced in my day-to-day work. I'll just add maybe two more. So one of the barriers that I see is so the Climate Change Act envisions that the Cabinet Secretary and the Council, the National Climate Council, will impose climate change obligations on private entities, and that there'll be regulations that are made on these duties and obligations, and they'll even, we will have modalities for measuring performance and all that. Now, since 2016, those obligations have not been imposed specifically on private entities, and we don't have these modalities of monitoring and verifying the performance. So as it stands for corporate entities in Kenya, we don't have any specific obligations placed on them. We do have the general obligation, for example, under Article 69, that says everyone has a duty to protect the environment. But the act, that is the act that deals with climate change, envisioned more specific duties. So I think for litigants and for aggrieved parties, it will be difficult to hinge on a specific obligation or duty that a corporate entity has done or failed to do because of this lack of statutory clarity on what are these obligations anyway. When we say there's a duty to protect the environment, if it would be better if there was actual targets, those actual reporting frameworks that a community or another entity that wanted to litigate on these climate issues could rely on. So from a legal perspective, I think that lack of a framework on those corporate obligations is a barrier and is a challenge. And then second, I would say also that I think what also litigants will face as a challenge is the fact that courts are good, but sometimes courts cannot do everything. So the reason I say this is because in as much as you can get a decision that is good for the litigant and is good for the climate, sometimes courts have to make decisions that they weigh on public balance. And I'll give the example of where, for example, a project has been undertaken and the land was irregularly acquired. In this case, it was a wind farm, but nonetheless, the court then gave the private or the corporate entity a year to regularize the process because that particular project was so important for the country. It's feeding the grid. So that sort of weighing of what decisions means that sometimes the powers that a corporate entity has and its significance in the economy is sometimes brought to bear in the courts. And then another thing that I think I've noticed, which also ties to the point that courts cannot sometimes do everything, is that you might have a decision, but implementing it becomes a challenge because in as much as you get a decision, maybe saying stop doing X because it's emitting greenhouse gases, it's not good for the environment, there are other structural vulnerabilities that the judge might not deal with that are also exacerbating the problem. And so for that reason, you find that there are certain places that a climate decision may not go and may not address really the socioeconomic needs that are really structural from a country perspective that needed to be addressed, or rule of law issues that might still persist, and then you have decisions not being properly adhered to or having the impact that they should.
Thank you very much,
Over to you.
Clarice. So now I think that with all your intervention here or your point of view, we have a clear idea of what is there in terms of hurdles. Now I would like to ask you something that is more, debated in this moment, which is the topic of the compensation. So I would start with the GOSA, with let's say, a little bit critical question. So do you think, GOSA, that compensation will be enough as a remedy?
Thank you very much. I think for me, from the African context and from the damage that has occurred over time from the activities of MNCs, the lack of political will by government to actually enforce and regulate the sort of oil and gas extractive sector and ensure the success of the implementation of environmental law, regulations, laws, and policies. For me, I think as it is now, compensation as a remedy is not enough. So if you even go through the toolkit that you guys developed, it says that in several jurisdictions, including Japan, Poland, Germany, Kenya, Netherlands, Norway, and Philippines, report a lack of cases, or as in the UK, lack of success in securing financial compensation. There are a couple of Nigerian cases where they've tried to take multinational corporations, their subsidiaries to court, and was never successful. They can't even get compensation at all. So, and also, he also suggests that the existing frameworks are actually insufficient in terms of providing financial redress for climate impacts, especially in quantifying such damages in many African countries. So as a further allusion, the report also states that further relying on monetary remedies is criticized as inadequate for addressing the broad spectrum of the anthropocentric contributions to climate change. For instance, within the context of Nigerian gas industries, costs are faced criticism for awarding minimal damages are failed to adequately compensate the claimant for their suffering and do not effectively deter polluting corporations. So in many African countries, adequate compensation has never been an adequate tool to ensure that the government and MNCs actually respect their obligations. So from the context of the Niger Delta in Nigeria, so many MNCs are pulling out of the extractive industry after decades of economic activities. They're saying that they're moving to net zero, low carbon economy. They are moving into other businesses. So now they've moved that away from the Niger Delta. They've worsened the environmental crisis in Niger Delta. So, however, some of these MNCs are now divesting from onshore and gas operations in Niger Delta. These MNCs still have an obligation to finance environmental restoration activities. They also need to decommission the disused facilities and also need to pay just compensation for other damages while ensuring proper consultation and thorough consideration of community needs throughout this process. So the question is, even within the existing framework, the compensation is not even enough, and many MNCs are actually leaving the onshore oil and gas operations. So the question is, who is going to take care of the 60, 70 years of continuous environmental damage that has occurred in the Niger Delta? For example, the same people who are suffering from environmental injustices are still the same social groups that are bearing the worst of climate injustices. So now, the same people suffering from environmental injustices are the same people that don't have the powers to mitigate and actually adapt to climate injustices. So the question is, how much monetary compensation can be enough for people who have suffered environmental and climate injustices for decades in African countries? So because the MNCs, some of them are still polluting the environment, some of them, the activities are still worsening greenhouse gases, then even the compensation is inadequate. And even if you even take the cases to court, one of the barriers, which I didn't mention, is that in many environmental litigation in Nigeria, it takes a long time. It takes, even the ones they take to the foreign jurisdictions, like the Bodo case in the UK, it takes a long time. And at the end of the day, after 5, 6, 7 years, peanuts are paid out as compensation. Now, the question is, the environment has been destroyed. The people's right to food has been damaged. Access to housing has been damaged. Access to farmland, access to water. They can't even grow their fruit. They can't even grow their food stuff in the farm. They can't even go to the water streams to get fish as fishermen and fisher people and fisherwomen. So the question is, how much compensation can we pay? So I think there's more to climate justice than just compensation. Compensation is just a tiny aspect of people getting justice. I think sometimes we overly focus on compensation. I think compensation is a reactive process at the end of the day. So until MNCs and the government know from day one the environmental human rights due diligence are actually incorporated in most of the activities. We don't do that as a society. We just give them the leeway to go, okay, let's go damage the environment. At the end of the day, we pay compensation. Even if compensation is inadequate, even if compensation, it takes forever. So the question is, there should be more than compensation. Remedies should not be solely about compensating. There has to be more. So who in a nutshell, who repairs the environment that has been destroyed? How much money for, since 2011, the UNEP report on the Ogoni land, up to date, Ogoni land is yet to be restored. Ogoni land is yet to be restored to his previous sort of quote, pristine environment. So for more than 13 years, we are still talking about remediating Ogoni land. So how much compensation after 13 years can actually do that? So that is just some of my thoughts. Sorry for the rambling. Thank you.
No, thank you very much, because I agree with you, and I see that that's why it's really critical, this topic, and it's also a big debate. And so that's why I would like to continue on that also with Lydia. So you've been part of our Kenya group of experts in the project. So the Kenya report also showed that a rights-based approach could allow compensation against private entities for these climate-related losses in Kenya. Could you please explain the challenge of climate compensatory claims, also from a global perspective that you have, and maybe outline why you think that the Kenyan legal system offers this possibility?
Thanks, Ivano. I think before I jump into responding to your question, just one thing that I wanted to mention and agree with Clarice, that there needs to be clarity on what climate duties are and how this can be used to enforce. Because if you look at Section 23 again of the Climate Change Act, it says that any person can go to court alleging that someone has acted in a manner that has or is likely to adversely affect efforts towards mitigation and adaptation. So the question is, what exactly does it mean to act in a manner that adversely affects efforts towards mitigation and adaptation? So I think this is also a bit ambiguous, and if the climate duties are clarified, then this might also help in enforcing this provision. When we say adversely affecting efforts, do we mean that these are activities that are preventing the country from meeting its mitigation goals? And at the NDC, do we mean it's activities that prevent the country from meeting its adaptation policy? So what exactly does adversely affect effort towards mitigation and adaptation mean? So I think completely agreeing with Clarice here that there's a lot of clarity that needs to be provided, not only by additional regulations that define duties, but also by courts interpreting or defining what exactly is meant by adversely affecting effort towards mitigation and adaptation. And then to get back to your question on the challenge of obtaining compensation, and while acknowledging that compensation can never be an enough remedy, I have to agree with the ghost on that. I think if we take a step back and look at what is happening on the global level, we see that as much as climate litigation has substantially increased over the past few years, it's actually failed, or it hasn't been much successful in providing the much needed reprieve in terms of compensation, because we see that a lot of climate cases that have sought compensation from private entities have largely been not successful in court. And when I mean about being unsuccessful, I mean in terms of positive outcomes in court and not implications or, not broader implications or broader effects of such cases. So for instance, if we look, I think from in 2023, there were about 25, 30 climate compensatory cases that had been filed globally against private entities. But then actually there hadn't been a court that had successfully or actually, there hasn't been a plaintiffs or parties that have successfully been able to obtain damages or to obtain compensation. And the question is, why is it so difficult to obtain compensation or to obtain generally remedies for climate-related cases against private entities? And I think we have, the different panelists have actually already spoken about a lot of challenges that they have faced in Kenya, and some of these are not just particular to Kenya, but also from a global perspective. So if we look at what has been some of the challenges, we take a step back and we look at issues such as cause of action, issues such as standing, issues such as linking injuries to activities of certain entities. But I just want to highlight a little bit about the cause of action. I think one of the questions is usually what cause of action is actually suitable to obtain or to be successful in a climate compensatory claim. Do you go for private law or do you go for a public law cause of action? And we see that most of the cases that have been filed globally seeking compensation against private entities have been based on private law cause of action, mainly either common law under the common law system or civil procedure under the civil law system. And the private law causes of action have actually faced a number of challenges. And I'll give you an example of the US, for instance. So the US, a lot of cases have been dismissed due to what we call the displacement doctrine, which basically means that federal common law tort cannot be applied when an issue is regulated by statute. And what the courts have said that in the context of climate change, the courts have held that global warming is actually displaced by the Clean Air Act, because the Clean Air Act regulates climate change, and therefore the courts have no subject matter jurisdiction, and the courts will not hear these cases. But then the problem that we see in this example is that while Clean Air Act actually regulates, pollution and could regulate global air, it does not provide for a remedy of damages. So it doesn't provide for remedy of damages from the harms arising from the very pollution that it actually purports to regulate. So what this happens is we see the plaintiffs are left with limited, or even if courts take this approach, then plaintiffs are left with limited or even no other avenue to seek for remedy, because they're being told, hey, your claims are precluded from common law, private law causes of action, because the Clean Air Act, your cases are precluded from common law causes of action because the Clean Air Act addresses this. But at the same time, the same statute that regulates this does not provide for an opportunity to recover damages. So this makes it difficult for private law cases in places like the US. And there are also a range of other challenges. And then the second question would be like, okay, then there's this issue of private law cases being a bit more difficult because you have to prove possession, you have to prove, there's the issue of displacement doctrine and all this. Then what about the issue of public law? Can I use public law causes of action to be able to get compensation for climate-related damages? So generally in climate litigation, public law is usually considered as an easier to navigate when used for climate litigation. But then when you use it to seek compensation, then again, there's a share of challenges that one is likely to face. For instance, there are some jurisdictions that do not allow horizontal application of constitutional rights. So if they don't allow horizontal application of constitutional rights, then you can't bring these cases against private entities. And in some jurisdiction, then anyone who brings a case claiming a public right or interest have to show that they have suffered some injury greater than other members of the public. So these procedural issues in public law then makes it challenges to obtain damages for injuries, which are diffuse in nature, like those arising from climate change. So these are the challenges from a public perspective, but I think that A rights-based approach in Kenya offers the possibility for compensation. So when we narrow back to Kenya, we see, yes, we have challenges at the global level, and it's been a bit difficult for parties to obtain compensation. But then how does the Kenyan legal system address some of these challenges that prevent parties from being able to obtain compensation? So I think one of the things that we have to recognize, first of all, is I already mentioned this, that we have a liberalized standing in public environmental law cases, which also applies to climate cases. But then also we realize that our constitution allows for horizontal application of constitutional rights, which means that if you are enforcing environmental rights, then you are able to enforce this against private entities. And then also, if you look at the issue of proof of violations, the Constitution as well as the Climate Change Act have done away with the need to show injury to be able to succeed in climate cases. And I think that despite the issues that I mentioned in terms of compensation and clarity, we recognize that the legal system provides this opportunity and addresses some of the challenges that parties in the global, in other jurisdictions have faced. And for instance, what we see from environmental cases is that courts usually, in environmental cases, parties are not usually required to provide scientific evidence to show that their rights have been violated. And this trend, we see that environmental courts in Kenya have a tendency of accepting general evidence of potential harm as a probative likelihood of damage. And what this does is that rather than the court saying or requiring that you have to show evidence or you have to provide scientific evidence that shows that this activity actually caused this harm and this is how you got injured, the courts are usually, they accept the general evidence of impact, especially when rights are being enforced. And because of these issues, and I think because of how Section 23 has been drafted, I think it provides an opportunity, although it has its challenges, but it provides an opportunity to seek for climate compensatory issues, but climate compensation, but also it addresses a lot of challenges that we see a lot of claimants facing in other jurisdictions.
Thank you very much, Lydia. That's really enlightening, and I think that I would like to continue on that, to ask to John, taking stock of what Lydia just said, what is your opinion on the effectiveness of compensation as a remedy in the Kenyan legal context before the Kenyan courts?
Thank you very much, Ivano. I want to agree with Dekker and Lydia that indeed compensation is rarely enough, and in places like Kenya, even where that compensation is awarded by the court, again there is always that challenge of whether these litigants will even get that compensation. So there will be always this narrative that the government doesn't have money. There is always the narrative that how do you even execute against the government when it tells you that the amount is not even budgeted in the country's budget. So for me, I think compensation is rarely effective in Kenya. And I would move towards probably more effective remedies around adaptability, probably trying to mitigate, and even trying to prevent the harm. Is there a way that we can prevent that harm? And like Dekker has said, how much remedy or how much compensation can you give to a community that the harm will continue for almost 60 years? I think Kenyan courts have tried to address this by giving some awards. These awards have been taken, I think, to be ridiculous, like a case in Mombasa. But I think the idea by the court in that case was that it was trying to remedy a problem that would still subsist for almost more than 60 years. An example is a community probably affected by cancer. How much compensation can you give to that community, if at all that community is going to be affected for the next 100 years?
Thank you very much. Yes, this opened a lot of interesting discussion, also very difficult ones. So I see here in the chat there is somebody from the audience that is asking to slow a little bit our speed for the panelists. So Clarice, as climate litigation, as we saw, we discussed, all of us, increases globally. What do you think are those innovative remedies that are emerging in the different parts of the world that can offer, in a way, some lesson for Kenya on redress for corporate climate harm?
Yeah, I think from what I've seen so far, what Kenya needs to look at more keenly is the innovative approaches that some countries are now putting in place, particularly, for example, as Kenya has now used, especially the Climate Change Act and the regulations thereunder, a sort of have introduced criminal liability. So I think one of the innovative things that we need to do is ensure that we have sentencing guidelines that provide clarity on what the requirements are on the part of imposing these penalties on corporate entities. So from my review, I found that Kenya has sentencing policy guidelines of 2023. However, when you do a search on them, there's no mention of corporates or organizations. The focus seems to be on individual parties, so to speak. But if you look at the US, for example, their sentencing guidelines have a chapter that is purely dedicated to corporate sentencing and how corporates can comply with the penalties and how courts can sentence. And then what you find is that one of the policy guidelines, for example, is that penalties that are issued should be proportionate to the size of the company and the nature of the offense. Now, if Kenya had such a guideline, for example, we would not have the situation that we have right now where the Climate Change Act has a one-size-fits-all penalty of 500 million Kenya shillings or 10 years imprisonment. If we were utilizing a policy, it would be able to cater to the different tiers of corporates and the different kinds of offenses in a way that then it makes it easier to comply. I think part of compliance and enforcement is not just about there being a provision on that, but the nature of the provision has to also be one that encourages compliance. So I think that since we have used, or we have chosen to use that criminal sanctions approach, and we have remedies thereunder, we need to have some sentencing guidelines. And I guess this would also go hand in hand with what Lydia was saying about also compensation guidelines on the part of civil remedies. The second thing I would say is also the fact that we might need to rethink how our fines structure that we've set up, how can it feed back into the environment and protect the environment and do things for climate, to improve the climate change situation. So currently, fines are collected, but they are not remitted for environmental purposes. If you look at countries, I think the UK, there is a system in place where fines that are imposed on companies for environmental offenses are utilized for environmental charities and are directly remitted for environmental charities. So that sort of innovative way of looking at the criminal sanctions with regards to sentencing and fines, and whether the use of those fines can actually be channeled back to the communities who have been aggrieved, as opposed to going to a pot that is utilized by the court and the government, but it's not earmarked for environmental issues. could be an innovative approach that we can use. Then our third, I think, innovative idea that we could also consider, though it might be subject to a lot of hue and cry, depending on where you sit with your support for against the carbon markets, is the use of purchasing carbon credits as a way of, if you've been penalized as a corporate, you're then, one of the ways you can offset that penalty is through purchasing carbon credits from the numerous projects in your country. And this has been done in China. And well, there has been a bit of question about it, but it could be, if well structured, could be a potential remedy that supports the environmental projects. And then we also need, lastly, some guidelines to courts on how to determine climate cases. And China's Supreme Court has issued such guidelines for their courts in the country. And I think Kenya would benefit from such guidelines that would be helpful on the issues of compensation and others. Thanks, Ivano. I know I've not answered on specific climate cases, but it's more of a broad overview of the different innovative ideas from a sentencing or remedy perspective and in the environmental space generally.
That was perfect. Thank you very much, Clarice. So I would ask Egoza also, if I can, what do you think about these lessons that can be learned from other jurisdictions regarding these effective remedies in climate litigation in Africa? I know that you have some ideas on that too.
Okay, thank you very much. I think there's a lot that can be learned from other jurisdictions, even just generally, for common law countries. For example, Kenya, Nigeria, for example, many of the courts in these countries, the issues of other Commonwealth states do have some persuasive impact. For example, I think there's a lot to learn from cases in India, for example. There have been recent cases in India as well that can impact positively on the way remedies is actually how to get effective remedies, maybe adapting ideas from other jurisdictions. But if you also look at the toolkit as well, it mentioned a couple of cases from Brazil and from other parts of the world. So I think I'll just speak of one of the cases in terms of these issues around the Greenpeace France case in France, in which the plaintiff sought damages for harm caused and moral prejudice, talked about how deceptive commercial practices undermine environmental protection, a central aspect of the plaintiff's activity. So issues around maybe climate washing, for example, issues around greenwashing, for example. How can we hold MNCs accountable for their public environment in terms of their respect of international climate obligations? Yes, MNC, we don't have under international law, we cannot say that MNCs can be regulated fully under international law, but there's that moral duty on MNCs to ensure that at least if they say they are moving towards net zero, they need to respect it. If they're moving towards, so in a way, can we get ideas from other jurisdictions in terms of misleading statements made by MNC? I think there's a lot that can be learned, and the toolkit has actually provided a lot of examples. And also, another thing we could also do as well, not just learning from other foreign jurisdictions. Can we learn from a country like South Africa, for example? So I was listening to a talk by Brandon yesterday in terms of the impact of the Climate Change Act in South Africa, in terms of just transition, for example, in terms of energy transitions, for example. How many of these climate justice, Climate Change Act in Africa do actually talk about energy transitions, do actually talk about just transition? So in a way, can we learn from a South African example? Can Kenya courts learn from South African courts? So in terms of even the sub-regional courts, for example, there are a lot of cases by the EAC, for example, a lot of cases potentially under the ECOWAS Court of Justice. So there's a lot of learning that can be done within, amongst African states and from foreign jurisdictions, and also relying on sub-regional and regional sort of tribunals or courts under the African Union law system, under the human rights system in Africa. So I think there's learning that can be done. But the other issue for me is that, yes, we can learn from each other. The question is, how many lawyers, how many lawyers actually are aware of these decisions? Yes, many of us, some of us are academics, and it's also good that we have NGOs and lawyers on the ground. But the question is, how many Nigerian lawyers are actually aware of the impact of the Climate Change Act? The Climate Change Act was done in 2021, to my knowledge, and I'm not sure there has been a case that has tried, that has looked at the remits, the impact of these cases. So in a way, I think we also need to talk about environmental education, climate education, and awareness. So we also need to what have NGOs done successfully in South Africa that Nigerian NGOs can adopt? What have NGOs done successfully in other parts of the world that African NGOs can adopt? So there has to be a cross-pollination of ideas, and we need to be open to receive ideas. I also try to create our own indigenous solutions to some of these issues. Thank you.
Thank you very much, Igoza. And by the way, tomorrow we will have a workshop session with the NGOs. We are going to explore the role of NGOs in this kind of litigation. And Igoza is going to be our chair, so don't miss that part. I just would like to ask the last question before leaving maybe a few minutes for some question from the audience to Lydia. So, Lydia, last but not least, we come back again to the rights-based approach in corporate litigation. So, taking stock of what was said in the previous panel by Dr. Odhiambo, do you think that this kind of causes action offers also the opportunity to overcome the challenges we highlighted, and also the possibility of obtaining compensation against private entities?
I think I touched on this before. I touched on this a bit before, and I will just highlight that. Yes, the Kenyan legal system provides a possibility of getting compensation or climate compensatory claims, and as I mentioned, I think it addresses the challenges, or it provides opportunities that addresses some of the challenges that litigants in other jurisdictions have faced. And we have the Constitution, which provides for the right to clean and healthy environment, but also allows for enforcement of this right, which also then gives the wide local standard, but also liberalizes issues like possession, and also gives the different options, which includes compensation. So I think a rights-based approach provides this possibility in Kenya. I think I'm not saying that I'm not saying that private law cases do not provide an avenue. I think they still do, but I think there's likely to be a lot of challenges. There's likely to be a lot of work that will need to be done there, including, a lot of science, a lot of proving that certain injuries have occurred because of climate change, and then linking certain injuries have occurred because of certain events, and then linking these extreme events to climate change, and finally putting it back to specific entities that you're claiming compensation or damages from. So it's still going to be possible, but I think this is going to be much, much more difficult if you compare to rights-based approach. And I think one thing that I think I want to point out here is that we see that globally people are being creative in terms of these private law cases. So we see, yes, they're facing these challenges, but they're trying to be creative about it. And I think one of the cases I find quite creative is the Liluya versus RWE case, which has been filed. Which for those who might not know about the case, it's a Peruvian farmer who's saying that his farm is going to be flooded, and because of that he's gone to Germany. So he's from Peru, a Peruvian plaintiff. He's gone to Germany and is suing an energy company, which is RWE in Germany, and claiming compensation. And what he's claiming is just not what has been damaged. What he's claiming is the cost of adaptation, the cost that he will have to incur to put in place adaptation measures in the future. And what I find creative about this is how the claim was designed by the plaintiffs. And they're not saying that RWE or the defendant is the cause of all their problems. It's like, yes, they've contributed, and what they do is they use publicly available science where they say, based on this carbon measures report, RWE has contributed 0.47%. So I know my cost of adaptation is going to be whatever amount, but I'm only seeking 0.47% of this cost from the defendant. And this is, I think it's an interesting way to see how people are innovative. First of all, going to jurisdictions that are not your own jurisdiction. So he's a Peruvian farmer, plaintiff from Peru, going to Germany to sue a German company, but then also how the claims are now being structured to be able to go around some of the issues or some of the problems that come in proving cases or being able to get compensation in climate cases. So I think this is quite a creative way of doing this, and also how climate science is being used, and also publicly available climate science is being used. Not only that you have to get a scientist to do the attribution science, which is, yes, it's relevant, it's useful for these cases, but sometimes also we find that this publicly available science is supporting some of these cases.
Yeah, thank you very much, Lydia. Indeed, I think also that this Ogiek case, I mean, might open the floodgate in climate litigation also, because yes, it's based on some science we already mentioned before, the Climate Accountability Institute. And if you consider this 0.47% that Lydia mentioned, correspond just to $20,000, which is nothing if you consider what I told you before this morning about the $209 billion that the company should give every year, even it should owe every year for the cost of that adaptation to the population that are affected by climate change. So in a way, we are exploring this new field. We see that science is going to be always very important, and I would ask now if there is any question about what has been discussed by our great panelists. Any question from the audience home or here? Somebody has any burning questions for them? No? Okay, so it means that you are so clear and you covered everything. Yeah, of course, there is the question from Oswald, so please. Yeah, okay.
Thank you very much to all our presenters. Discussion was very, very informative. Thank you very much. I have a question, but just give me 30 seconds to create context. So in certain situations, effective remedies in public climate litigation require that offending corporate concerns are shut down or significantly undermined focus on protecting the climate. However, in some African countries like Nigeria, we find that the courts are hesitant to issue injunctions to that effect, but prefer to offer monetary compensation to direct victims of the offensive operations. These corporations. Sometimes they make it clear that this approach is adopted to protect the nation's economy, where the corporation operates in a sector that is critical to the nation's economic need. Right, so this gives rise to the following interrelated questions. One, are such drastic economic remedies in corporate climate litigation unsuitable for Africa, considering the continent's relatively minute contribution to climate change and its need to build its economic financial capacity to be able to better adapt to the effects of climate change? Secondly, does the principle of common but differentiated responsibility provide support for a differentiated approach to effective remedies in corporate climate litigation in the global north and south, such that an effective remedy in Africa may include one that focuses more on addressing the immediate human and environmental consequences of climate-friendly activities, unless efforts to address the overall climate effect.
More a comment than a question.
Okay, so those are two questions. Anybody?
Who want to jump on that?
I'm happy to jump on.
Lydia.
Yeah, I'm happy to jump on one of them. I think he raises quite an important question of, does it even make sense to sue for compensation, considering that the contribution of African countries is actually quite minute to global greenhouse gas emissions. And I think one thing, I agree with you on looking at it from a justice perspective of, does it make sense to go and seek compensation or to look for, to sue for mitigation, for stronger mitigation measures when our contribution is not really that much. And I think this argument I would take on it first from who the defendant is. If we are talking about the state being the defendant because you are suing the government to tell, I don't know, the Kenyan government or Botswana or Lesotho government that, hey, you need to put in place stronger mitigation measures. I think this raises a question of, is this the right place to go? Is it right to go and ask the government that contributes a really small percentage to mitigation to mitigate more? Or should the cases that are filed against the government should maybe look into, adaptation and maybe probably having policies that do not lock countries into carbon-intensive economies and all this. So I think this has to be looked at from who the defendant is. But also, I think something that's important is when we are talking about corporates, we are not saying that you should. We see that multilateral corporations around the world have contributed a substantial amount. So we are not saying that it's going to be a Kenyan company that is being sued here. It could be a multilateral organization. It could be Shell. It could be, I don't know, RWE, the way RWE was sued. And I think if you are targeting corporates that have actually contributed to the problem, then I think it's not a problem that we should be following up those who have contributed to the problem. And then I think also we need to realize that a lot of African countries are very vulnerable. Our communities, our people are very vulnerable, and they will need to put in place adaptation measures. Where are the finances going to come from for them to be able to put adaptation measures when they do not have when they have other development problems? Then why can't we ask the companies or corporates that have contributed the biggest to the problem to then contribute to the cost of adapting, contribute to the cost that these people need to adapt to? I think if you look at it from that perspective, then it makes sense to go for climate compensatory claims against corporates that have actually contributed a substantial amount to the problem.
Anybody else?
I think I could also just add on to what Lydia has said. She said the question is, you could ask is who the defendant is. I think I'd also add, what is the harm or what is the violation which is the subject of the corporate litigation? I think that would also determine whether a high economic remedy should be actually be what we are focusing on as an African country. And I'll give the example of, for example, a carbon project where the issue at hand is infringement or failure to account to communities with regards to benefit sharing, for example. In such a case, I think an economic or pecuniary remedy would actually be very much appropriate in such a case, just to ensure that the corporate has directly and is actually even a financial benefit that could be quantified, and the community has not received what was due based on maybe the benefit sharing agreements in place. So the question of who the defendant is, as Lydia said, is important. And I think also what is the cause of action grounded on or founded on would also be important in such a case.
I think I'll just jump in as well. I think for me as well, the jurisdiction also matters. Where are we instituting cases? So are we saying foreign climate litigation cases in the West? Are we saying climate litigation cases in Africa? To me, I think for me, the jurisdiction might also have impact on my answers as well. So if we take a case to maybe if it's instituted in the UK, for example, I think I will argue for more payment. But if you're going to institute that same case in an African court, can we compel the UK subsidiary or the US subsidiary to actually pay? I think there are a lot of issues at stake. So, and also I think no matter the perspective we take, MNCs cannot, or Western states cannot use the excuse that they cannot provide. They have to. There is duty bound on them. The MNCs make so much billions of profit every year. So what they spend as CSRO is less than 1% of their profit. So what the adaptation and mitigation should be part of their business strategy from day one. We should not tell them they have to do that. It should be part of their CSRO. So being good corporate citizens. MNCs should do that. So I think MNC, society, government, activists, you have a role to play, and jurisdiction to me matters. Sometimes you're going to get in terms of justice or getting the funds to actually develop all these adaptation and mitigation sort of strategies. Thank you.
Yeah, let me try to weigh in. I think we should also just look at the perception that probably citizens in the country may have, in that we may look that like we are protecting, for example, corporates, and this may have an effect, and it may look like we are being cozy with corporates, and these are the corporates that are really harming the environment. So for me, again, I would also look at the level of harm that this corporate is causing. And I think that hypothetical issue that you've raised, we are trying to balance between the economy and the harm that is being caused to the environment. So for me, I think we shouldn't appear like we are protecting a corporate while trying to protect the economy.
Absolutely, thank you very much. There is a question here. Thank you very much.
Hi, my name is Laura Otieno. Mine is not a question, but rather a comment. I think we need to move beyond looking at remedies as a success when it comes to climate litigation. So the fact that we are having these conversations, engaging communities should also count as a success, particularly in Kenya. And as it's been today, engaging the Gen Z in climate litigation is also important, and that should count as success beyond looking at the normal remedies such as compensation. Thank you.
Thank you, Laura. Yeah, I think that this really goes in the category that is really important in this field, that is the strategic side of litigation. And in a way, even though in this area we haven't seen so many successes, this anyway is a very important field. It's a very important part of the climate governance for what you were saying, because raise awareness, make sure that all the important components of the society feel also part of this change, and also can push as a consumer, as a citizens. And so I think this is absolutely a very important remark. And I think that we can close it with this because we are already almost 10 minutes late. I would like to thank all the speakers today. And I would like to thank, of course, Dr. Omuko for hosting us for this first day, Dr. Uzoazo Etemire, and everybody that participated in this very interesting discussion. Tomorrow we will start at 9:30 EA time, so we'll be here with the keynote address from Professor Damilola Olawi on the access to remedy for corporate harm in Africa. And then we will have other high-level panel, an online workshop, as said, on NGOs in corporate climate litigation in Africa. So we'll see you tomorrow. I think that probably if you can go to the chat, yeah, we have a form that we would like to ask you to fill out before leading this meeting. So thank you very much, everyone, for your contribution to this first day of this African Summit, and see you tomorrow. Thank you and goodbye.
Thank you. Have a nice rest of the day. Bye.
Thank
Thank
you.
you.
Thank you.